Here we have continuous coverage of Scontus hearing arguments against the left, libtards, ACLU, against Tennessee wanting to ban trans-affirming surgery care for minors. We're going to pick right up where we left off. This was 2.5 hours long. I'm only an hour into it because obviously I'm doing commentary in it. If you choose, go watch it with no commentary if you want to listen to it, or hang out with me and check it out. And if you like my coverage, please hit subscribe, like the channel, like the video, and it helped me out a lot. That would be awesome. And thank you. And here we go. Let's get into it. So we left off of the same old crap. They're trying to say what? Trans is a sex. Trans is a sex. They touched a little bit upon one of the Scontus was bringing up other cases dealing with minorities or old folks and things of this nature, which I thought, this really doesn't have anything to do with this. This is just the fact that the bottom line is, and it seems to be a no-brainer, should a minor get life-changing surgery that can never be undone once it is done? Period. That's it. Or letting a parent decide for them too. And here we go. Let's get on with this. We got a lot to cover.
Thank you, counsel.
This court to say that a statute that on its face says you can't have medications inconsistent with your sex, and in part that's because we want you to appreciate your sex, isn't drawing a sex-based line in the first place. That would have no correspondence to or grounding in the text of the statute or how it works in operation or what effects it produces for individuals on the ground.
Thank you.
Thank you, counsel.
I think it could have some context in appreciating who you are. They're not teaching the kids nothing in school. They're not teaching them how to be patriotic. They're pretty much not even teaching them about. A lot of kids don't even know why we celebrate 4th of July. It's just absolutely ridiculous. But I know it starts at home as well. Teaching morals, morality. Respect others, respect yourself. Teaching them that, hey, you're going to go through a tough time. You're if they're a teenager. Like I told my kid, yeah, you're going through puberty. You're going to be thinking all kinds of crazy things. You're going to think you're going to want to be something, and then in 2 years down the road, you're going to want to do something else. As far as even a career is concerned. You're going to change your mind, even as something as basic as on a career for the rest of your life, that you keep changing your mind because you're evolving. So to sit there and go, okay, well, you can change your major. You can change if you want to do another career. But once you've done the surgery, you can't change back. It's done. It's a done deal. Let's go.
Mr. Strangio?
Mr. Chief Justice, and may it please the court. On its face, SB 1 bans medical care only when it is inconsistent with a person's birth sex. An adolescent can receive medical treatment to live and identify as a boy if his birth sex is male but not female. And an adolescent can receive medical treatment to live and identify as a girl if her birth sex is female but not male. Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs. And critically, Tennessee's arguments that SB 1 is sex neutral would apply if the state banned this care for adults too.
I'm sorry. I'm laughing because she's saying that they're just suffering. These kids are just suffering. So, you know what we're gonna do? We're gonna get them mutilated, and they won't suffer no more. Really? This is gonna solve all your problems. I mean, they are suffering, and we have got to mutilate them. I mean, this is ridiculous. Stop the suffering, people.
By banning treatment only when it allows an adolescent to live, identify, or appear inconsistent with their birth sex, SB 1 warrants heightened scrutiny under decades of precedent. Because the Sixth Circuit failed to apply that standard, this court should vacate and remand. I welcome the court's questions.
If you are successful, what would your remedy be?
Your Honor, if we're successful here, the remedy would be to enjoin the state of Tennessee defendants from enforcing SB 1 as applied to our individual plaintiffs.
So in practical terms, what would it be? What would you get? Wouldn't you get you would get different treatment based on sex?
In practical terms, what it would mean is that an individual like John Doe, who was receiving medical treatment to undergo a typical male puberty prior to SB 1 and is now barred from doing so because his birth sex is female, could then receive that treatment as he had been doing with the consent of his parents. So his sex would no longer be the basis for the denial of the medical care that his doctors recommended and his parents consented to.
Oh my God, here we go with the word salad. Talking about a female, but calling him a he, calling her a he. It's word salad. For years I always thought we've been butchering the English language. I mean, kids can't even read or text properly. They have to use abbreviate everything. It's just, let's keep butchering it some more in the court. Let's be clear. Let's be crystal clear that he was born a woman, but he, and keeps referring to as he, it's unbelievable.
Counsel, is there any significant respect in which your position departs from that of the Solicitor General?
No, Your Honor. The only argument that we make before the court here that the Solicitor General has not advanced is that this is a law that fails under any standard of review, that it is so discontinuous with the asserted interest in protecting children and therefore fails under any standard. But we think, as the Solicitor General made clear in her remarks, that it is clearly a sex classification on its face and should be resolved on that basis and remanded for the Sixth Circuit to apply that standard in the first instance.
Yeah, we have to protect the children from you, from your ilk. We have to protect them because they can't protect themselves. They're the most vulnerable. Besides the elderly and the infirm, special needs, children need protection. They need special protection because they can be manipulated into doing things that they end up regretting later. That's the protection the children need.
Is there anything you would like to add, and maybe there isn't, but with respect to the Solicitor General's responses to my concern that this is unlike a case like Craig versus Bourne, unlike a case like Morales, and those where it was quite clearly simply stereotyping with respect, can men have the same rights as women with respect to adoption and the liquor laws? This does strike me, whatever you think about the disagreements between where Europe was some years ago and where Europe is now, where Europe is, where the United States is, in that it is quite a distinct type of inquiry that involves medical expertise, predictive judgments in the medical area than in those cases?
I don't dispute, Mr. Chief Justice, that at the application of heightened scrutiny, there will be particular considerations that involve the underlying medical evidence, as there always is. But I don't think that it would break new ground to apply heightened scrutiny here. The purpose of applying heightened scrutiny has been because, in part, we don't know at the outset whether a classification is benign, and many justifications for sex-based differential treatment in law were defended on the ground of biological differences and were upheld by the court under rational basis. And the role of heightened scrutiny is not to make sex a proscribed classification. It is just to shift the burden to the state to show their work and show that, in fact, this is a law that substantially advances an important governmental interest.
Counselor, are there other situations, the Chief Justice's question just made me think of this, in which any of our levels of heightened scrutiny, whether they be intermediate or strict, require courts to make the judgment, the means-ends calculation in this kind of medical context? Because I agree with you. I mean, I can see your point, like, well, as a matter of logic, we should shift this to that stage, assuming that the suspect class is triggered and we say this is sex classification. But is there any other situation in which courts get into that in the tiers of scrutiny?
I mean, so I would point, Your Honor, to recent cases involving the COVID-19 pandemic, in which many cases came up before this court, in which the states were regulating, undeniably in areas of public health and evolving science, and the court repeatedly made clear that yes, of course, the states have latitude through their police power to regulate, but when they do so in ways that classifies based on suspect lines or infringes constitutional rights, then heightened scrutiny remains the standard that the courts apply to ensure that the state is advancing an important governmental interest.
Yeah, I guess I'm thinking of some. Can I just last follow-up? But even in those COVID-19 cases, courts weren't, and we certainly weren't, diving deep into the medical evidence and comparing Europe and America and looking at research. I mean, this would be, I think, of a different order. Do you agree?
I don't agree, Justice Barrett, in the sense that I do think it is precisely the role of the courts to assess the tailoring and look at the evidence, whether it's presented through expert testimony or not. It is not the role of the court necessarily to say definitively these risks outweigh these benefits or vice versa, but do what the district court did here, which is to look at the assertions of harm, make comparisons to how Tennessee treated all other medical care, and then see whether or not Tennessee had met its burden under heightened scrutiny. That type of tailoring inquiry, I believe, is precisely the role of the court.
Counsel, in the COVID, I have a colleague to my right, whom I think very highly of, who spoke about the need of the courts to look at that evidence to ensure that there wasn't suppression of religion, correct?
That's correct, Justice Sotomayor.
Now, with respect to Justice Barrett's question on COVID, in my mind, it's a little more similar to the bathroom situation, because there, COVID was a risk not just to the individual and the threat to their own life, but their contact with others could threaten others. So the compelling state interest was different than just a pure medical issue, correct?
That's correct. I totally agree. The state interest was different.
All right. With respect to treating that issue, you can hear from some of my colleagues that they're worried that, and there is a plethora of science in this area, both that developed in Europe, and the lower court hasn't really looked at it. No one has. That courts are ill-suited to that. Why do you think they're not? What about the fundamental role of the court makes us suited to answer those questions?
Well, I think first, Justice Sotomayor, the role of the court is to ensure that when the government draws lines based on suspect classifications, that the states are tested to ensure that they're substantially advancing an important governmental interest. And when it concerns underlying questions of medicine or science, the judges and judges in the lower courts have every ability to assess the testimony before them, as the district court did here. This is not an area where I believe Tennessee is saying that medicine is altogether an area in which suspect classifications have no bearing on the judicial inquiry. It is precisely the role of the court to ensure that the government of Tennessee has substantially advanced an important governmental interest.
I have one small question to finish with. The regret issue that was raised to the Solicitor General. Respondents cite a figure of 85% of children expressing gender dysphoria regret later. You use a figure of 1% of minors who receive this treatment expressing regret. Can you tell me where those figures lie and exactly what the difference is between that 1% of children who receive these treatments expressing regret and the 85%?
Certainly, Justice Sotomayor. And so the first point I would say about the 85%, and we address this on page 22 of our reply brief, that's a misleading figure for two reasons. I think most critically, it refers to older studies of prepubertal children. And everyone here agrees that the medications that are banned by SB1 are only prescribed to individuals after the onset of puberty. And so in JA 151 to 153, the evidence shows that once an adolescent reaches the onset of puberty, their likelihood to ultimately desist and identify with their birth sex is very low. And then as to the question of the 1%, the question of regret, which is a different question than what happens with prepubertal children, the record shows there that the rate of regret when people receive this medication after the onset of puberty is as low as 1%, and that's in JA 131 to 133. And I think what's important here, and the Solicitor General mentioned this, is that is exponentially lower than the rates of regret of treatments that are expressly permitted by SB1.
Thank you, Counsel.
Could we explore what...
Wait a second. Word salad. I want to see hardcore stats on the percentage. She says the percentage is low of regret. The percentage is low of regret. But I think it's opposite. I'm not sure who's talking, but I'm thinking, and I forgot her name. I should have wrote it down. But one of them arguing for the libtard side, and it might be her. Forgive me if I'm wrong, but one of them had testified that said she can't define what a woman is. So that, to me, that should just disqualify her from even arguing any of this. She doesn't even know what a woman is, but she's arguing some medical, scientific procedures on a minor that are serious with drugs, surgery. We're talking stats. And she can't define what a woman is. So she's going to argue that a man can become a woman and a woman become a man on a minor. I just wanted to throw that out there.
intermediate scrutiny might look like in operation in assessing laws like Tennessee's. So the Solicitor General on page 48 of her brief lists a lot of things that she says, well, if Tennessee were really concerned about the health and welfare of these minors, it would have taken into account a variety of things. So one is waiting periods. Another is whether puberty blockers should be exempted. Another concerns things to make sure that the future of these minors is properly respected, even though they personally cannot make mature judgments about potentially irreversible procedures. So she mentions things like two-parent consent or counseling, readiness criteria, age recommendations, licensing, certification, or reporting requirements for physicians, and other guardrails which are not specified. So if intermediate scrutiny were the regime that would apply, would it not be the case that judges would have to decide whether a particular package containing this much of that and that much of the other thing is sufficient? Wouldn't this be endless litigation with the decision based on determinations by lay judges regarding complicated medical issues.
Wow, excellent point. That is astoundingly excellent. So you put all this gobbledygoo in there to say that you're reinforcing the affirming of the mutilation. Let's call it affirming mutilation. That two parents, doctors, the kid too, maybe some psychiatrists, all of y'all got together to decide this for a little kid. To me, that's grooming them into walking off a cliff. Just jump off the cliff. We all got together and we think it's okay. Do you think it's okay? Stand off the cliff and look down. It's not too high, is it? Go ahead and take that step. So you're putting all of this in place, but then I just posted I just posted a video on the bill, and they did have in there that if this bill stands, there was a part in there that said something like 30 years down the road, 20 years down the road, if the death occurs, I guess if they're offing themselves or there was complications and all of this stuff, that these medical people can be civilly sued. Civilly sued. I'm waiting for them to start talking about that.
So if I could make 2 points in response, Justice Alito. And the first is going back to the Solicitor General's example of West Virginia, where West Virginia looked at the underlying science and instead of categorically banning this medical treatment, created pathways with guardrails for individuals to access medical care. There has been no litigation over West Virginia's law, and if there were in other contexts, the question would remain whether or not the state could make out the showing that this is being treated in such a substantially different way than other forms of medical care. I do think that judges are equipped to make those determinations as they do in many other contexts.
A lot of categorical statements have been made this morning in argument and in the briefs about medical questions that seem to me to be hotly disputed. And that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think, as with all underlying questions of looking at evidence, there can be disagreement. I don't dispute that. But here, and sort of going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
Well, I don't regard the Cass review as necessarily as the Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
Oh.
What I think that is...
Which is common sense, because already we need to look at the fact that there's something mentally wrong with the minor, any minor in question. There's something wrong. Depression, they're going through puberty can be tough. Peer pressure, anxiety, a lot of different factors. Maybe there's issues at home. Maybe they're in a broken home. Bullying. There's so many mental factors that has nothing to do with physical health. It's mental health that needs to be addressed. And to say that just because you got some affirming care it's going to all of a sudden it's the magic bullet that all of a sudden the individual, the youth in question, is going to be all of a sudden happy and affirmed with their identity, because your identity kind of continues to change over time. I mean, a core of you is there, but your opinions, your political opinions, maybe your religious beliefs change, your career opportunities change. There's so many things going on. And look, who's to say that these kids are still depressed, and so they're giving them these depressed medications can cause off yourself thoughts as well.
Referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare, and we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term longitudinal studies, that do show that there is a reduction in suicidality, which I think is a positive outcome to this treatment.
Let me ask a question about another issue that came up during Justice Kagan's questioning and Justice Barrett's questioning in particular, and that is whether transgender status should be regarded as a quasi-suspect classification. And Justice Barrett referred to one of the things that our cases have mentioned in explaining when something should be classified as a quasi-suspect classification, and that is a history of discrimination. Another one is immutability. Is transgender status immutable?
May I answer, Mr. Chief Justice?
Sure.
So I would say that under this court's consideration of that criteria, it is a distinguishing characteristic. Transgender people are characterized by having a gender identity that differs from their birth sex. That is distinguishing and discrete. And that also within the characterization, I would also point, if I could, to the history of discrimination, and there are many examples of in-law discrimination, exclusions from the military, criminal bans on cross-dressing, and others.
Thank you, counsel. I think I lost track of the discussion you were having about COVID. What was the point you were trying to make?
Yeah, what's your point?
I think
Somebody was trying to make it.
Yes, I think it was me. And the point about COVID and the question of whether or not this court has ever considered applying heightened scrutiny to contexts in which states are grappling with evolving medical evidence. And I would point to Justice Gorsuch's statement in South Bay United Pentecostal, in which the purpose of heightened scrutiny, even when the government is grappling with experts of a medical character, is to still test whether or not that infringement on an individual right or that use of a suspect classification meets the heightened scrutiny standard. It is not exempt simply because it is in the context of public health or medicine.
Well, I don't want to relive the COVID cases.
You and me both, yeah.
But it does seem to me that one of the issues that came up, and as to which courts around the country had vastly different views, was the lack of knowledge about precisely what was going on, what the effects were going to be, what the remedies were going to be. If this is similar to that, I think that would be very troubling to say that in such a evolving situation, we are going to decide what the right approaches are. I mean, you said at some point that the Tennessee court, not the Tennessee court, this court is just as qualified as Tennessee to make the decisions here. And it's not really so much a question of qualifications, it's more questions of constitutional allegation of authority. And, we may think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor.
I'm thinking they're going to just say, hey, the Tennessee courts have decided, then it's Tennessee, and let it ride. I mean, they They should just kick it down and go, they shouldn't overturn what Tennessee's done, even just what he's saying. There's not enough evidence to overturn it. I mean, this is my little mind full of mush. This is what I'm picking up. Maybe I'm wrong on how this particular judge is stating his opinion. But it's clear that, hey, it would be unconstitutional if there's not enough evidence to back them wanting to crush Tennessee's ban when they're wanting to protect the children from these wolves mutilating them, and not enough back evidence on these drugs, on offing themselves, on creating a whole new sex, transgender, all of this craziness. And Tennessee's like, hey, we want to protect our kids. We want to do this. So there you have it. I mean, why would the Supreme Court overturn it unless it was really something egregious? And I'm not seeing this to be egregious to the people of Tennessee.
Particularly in, and maybe I'm just repeating myself, but you can look, should we follow the United Kingdom position from 3 years ago? Should we follow the United Kingdom's position now? It seems to me that it is something where we are extraordinarily bereft of expertise.
Well,
anyway, just what you think.
Mr. Chief Justice, if I could first respond to the first half of your question about whether or not this is comparable in terms of the underlying science with respect to COVID-19, and I think absolutely it is not. I merely use that example to say that the court has not hesitated to suggest that heightened scrutiny applies in contexts that deal with medicine and science. And then with respect to what is the role of the courts, I continue to think it is to test whether or not a law is properly tailored, and that is what the district court did here. And in fact, the underlying science and the evidence showed that Tennessee's assertion of harm and their prevalence were not supported. The district court made factual findings to that effect, of which Tennessee has not argued were clearly erroneous. And so if what is left here is just bare rationality review, Tennessee is in essence saying, let's not look at the evidence at all, whether this is a law that bans this medical treatment for minors or for adults, that in all other contexts, what Tennessee does is recognize that there are risks and there are benefits. And usually the state regulates by informing patients of the risks and tailoring to minimize them. Here, what they've done is impose a blunderbuss ban, overriding the very careful judgment of parents who love and care for their children and the doctors who have recommended the treatment.
Thank you. Justice Thomas.
I don't think Tennessee is saying that an adult can't get this crazy crap done to them. They're saying we don't want this done to minors because they can't make this kind of decision.
The point I was getting at with respect to remedies is normally in equal protection cases, there's a difference between one group and another. In Bourne, it would be that the women could buy alcohol, but the male students could not. And what would that be in this case?
So 2 points, Your Honor. I think that what the birth males can do that birth females cannot do is receive medical treatment to live and identify as boys. And what birth females can do that birth males can't do is receive medical treatment to live and identify as girls. That's
okay,
what she should have said is birth males can live as a birth male. But birth females cannot live as a birth male. They can only live as a birth female. And birth males can only live as a male, but not as a female. Sorry. It's just absurd.
Let's change. What if, would you make the same argument if we were only talking about puberty blockers?
If it was puberty blockers, I would point to John Doe, who is receiving puberty blockers. The purpose of receiving puberty blockers for John Doe is so that in the future he can undergo a typical male puberty.
No, I'm talking about from an equal protection standpoint, the difference in treatment. Normally in these cases, one group receives something that the other group does not. And I'm trying to discern that in this case.
And so what I would say to Justice Thomas is that a birth sex male can receive puberty blockers to undergo a typical male puberty, and a birth sex female cannot. And if I could slow it down and just explain a little bit how that works. If you're someone who was born male and you are going through puberty too early, you want to be able to have a final adult height that is typical of boys. You may receive puberty blockers so that you can develop as a typical boy. Someone who has a sex of female at birth is also receiving puberty blockers so that they can undergo a puberty like other boys. And so it is the same purpose, and what makes the treatment prohibited for the birth sex female is their sex.
Justice Alito?
Counsel, I don't think you had a chance to finish answering my question whether transgender status is immutable. You cited a bunch of other criteria, but is it immutable?
I think that the record shows that the discordance between a person's birth, sex, and gender identity has a strong biological basis and would satisfy an immutability test. And I also think under this court's precedence for determining whether something is a suspect or quasi-suspect classification, a distinguishing characteristic is sufficient.
Does the category of, does transgender status apply to individuals who are gender fluid?
I think that the distinguishing characteristic is to have a birth sex that does not align with, or a gender that does not align with one's birth sex. So it may include people who have different understandings of their gender identity, but I think it is still the distinguishing characteristic of a birth sex and a gender identity that are incongruent.
Are there individuals who are born male, assigned male at birth, who at one point identify as female, but then later come to identify as male, and likewise for individuals who are assigned female at birth, at some point identify as female, identify as male, but later come to identify as female? Are there not such people?
There are such people. I agree with that, Justice.
So it's not an immutable characteristic, is it?
Well, I think people's understanding of it shifts, but that.
What a good point, because it is what it is. You are what you are. It ain't what it ain't. I mean, she had to agree with that. And this gets back to the point I've been making too, is that young people will change their mind. From the time you're 10 to 15, from 15 to 20, from 20 to 25, and so forth and so on, you continue to evolve. So you are going to be forever changing, and you might change your mind. Like a guy thinks he wants to be a girl, and then he's dressing like a girl, and then all of a sudden he's like, what the hell? I want to get married. I want to have kids. He wants to marry a woman, is what I mean.
Evidence shows that there is at least a strong underlying basis, and I think the normative reason for that particular consideration is whether or not this is something that someone should or could change, and whether they should have to change it in order to receive constitutional protections, and I think transgender status squarely fits within that.
We have said that having a disability is not a suspect or quasi-suspect classification. So if we were to agree with you on the question of quasi-suspect classification, how could we justify saying, for example, that a person who is schizophrenic does not fall within a category that is not a law that distinguishes on that ground is not a suspect classification? And I'm not suggesting that gender dysphoria is a disease, a mental illness. I'm not suggesting that at all. I'm just saying, how could we justify that different treatment?
I think that
it's immutable in the sense that there isn't any cure for it. There's been severe discrimination against people suffering from schizophrenia. At one point, they were locked up in hellish institutions. They can make a valuable contribution to society. Think of John Nash. How would we distinguish that?
Justice Alito, what I think would be the difference is that in Cleburne, the court in essence said as to the distinguishing characteristic that this was a large and diffuse group of individuals who have different forms of disabilities, and that group of people had been able to secure some protection through the legislative process. But again, if this court certainly does not have to reach the question of transgender status as a quasi-suspect classification, SB 1 on its face hinges its prohibition on inconsistency.
Well, I understand that, but would you dispute the proposition that transgender status is a very broad category? Doesn't the American Psychological Society Association say it's an umbrella term?
Yeah.
I don't know exactly what the American Psychological Association says, but I don't dispute that there are people who fall within a transgender identity who may not fit into a binary identity. I still think that the distinguishing characteristic applies to every single transgender person, which is a birth sex that is inconsistent with their gender identity. And of course, here on SB 1, this is a law that I think is easiest to understand and the most straightforward classification.
Thank you.
On the basis.
Wait a minute. If she's been doing her homework on medical research, on research on offing yourself rates amongst this group of people, a group of youths who have had these surgeries or taken these drugs over a long period of time, what is the psychological aspect of this? Because if you're going to off yourself, that's a psychological, that's you would need to understand the literature from them, and she says she doesn't know what they said. I don't believe it. I don't believe it. I guarantee you they went over all of this and then they picked what they could use. I mean, if I was them, that's what I would do, right? I mean, you're going to pick what you can use. It's going to best suit your argument. And she just blatantly says, well, I don't know what, I didn't hear that stat. I didn't see that. I don't believe it. I think they had a think tank, they had a team that prepared for this, and they saw all the psychological reports, all the journals, all the data that has been spewed on all of this stuff.
Sex.
Yes, Sotomayor?
So when asked whether you differed from the SG's position, I assume that if you win in this proceeding, what you're asking for us to reverse is the Sixth Circuit conclusion that rational basis review applied, correct?
That's correct, Your Honor.
Now, you think, as does the other side, that each of you should win on that question, but are you differing from the SG that should be remanded to the court below to apply strict intermediate scrutiny in the first instance?
No, Justice Sotomayor, we're not disagreeing.
Now, with respect to Justice Thomas's question, I'm not sure you answered it. You did in part, and you said the relief you're seeking in the lawsuit, assuming you win on the intermediate standard review, is to permit your plaintiffs to receive the medication other children receive. I don't know if he was suggesting that one of the things we can go up in discrimination or we can go down, which is, but I don't think we've even decided who makes that choice, because the other alternative is to block the usage of all of these drugs for all children,
Yes.
which would present a very different than Arlington Heights, perhaps, question. But the point is that what the relief is still something that has to be determined as well.
Well, so if I could clarify, Justice Sotomayor, I don't think that the relief we're seeking is for our clients to receive the medication. The relief we're seeking is for SB1 to stop being a barrier to their ability to continue to access medical care and make the individualized assessments with their doctors. So it is just simply an injunction of the barrier to the medication that they had been receiving in Tennessee.
Got it. Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
Two basic questions. So whether we apply rational basis or intermediate scrutiny, either way, you end up looking at the state's justification, and they are articulating a health and safety justification. So it's not simply morals legislation as they've described it. It's health and safety justification. And it seems that there are risks and benefits both ways here. So it's very hard to weigh those, at least as the briefing has set out the issues. If the treatment's barred, some kids will suffer because they can't access the treatment. If the treatment is allowed, these treatments are allowed, some kids will suffer who get the treatment and later wish they hadn't and want to detransition. At least that's how I see the positions set out in the briefs. And so there are risks both ways in here, allowing the treatment or not allowing the treatment. And how to choose there is a very difficult judgment call, it seems to me, but it's one, it's a difficult judgment call as a matter of policy. And then for us to come in, and this is repeating what I said earlier, but I want your reaction to it, for us to come in and to choose one side of that, knowing that either way, people are going to be harmed. There's no kind of perfect way out, at least as I've read the briefs here, where everyone benefits and no one is harmed, right? The difficulty of the issue is some people are going to be harmed.
Well,
And then the question becomes, how does the court choose which group? Why isn't that a choice for policymakers as best they can to make that choice in the first instance? So I just throw that out there and take your reactions and anything you want to say on that.
Okay.
Look, if a minor, if there's something physically really wrong with them, like something that's going to cause, okay, either, I don't know, like she brought up something and I'd never heard of that. Somebody going through puberty too quick or something and they wanted to slow it down. So I don't know how they figured that out and if the kid needed that. So I think something like that's what it's getting used for, not for transitioning. Transitioning isn't a health problem. It's a mental problem. It's a psychiatry problem. Another health problem that you would need testosterone, or if why would a guy need to take estrogen? Why would a woman need to take testosterone? The thing is, or the only thing I could think of is, like she said, for somebody to take puberty blockers is if they were going to puberty too fast. Maybe there is something, such a thing. I don't know. I haven't looked it up. I just heard it just now. But in those extreme cases, which I'm sure they're rare and far and few in between, then yes. Then probably, yeah, give it to them for that. But this is the fact of this thing here is strictly for transitioning children. Not the drug per se, puberty blockers. They're using the puberty blockers to take these children down this dark road and driving them off a cliff. It's not just because, like I said, she brought up something, they're going through puberty too quick. So for him to say, well, some kids are going to be hurt and then some aren't, either way they look, I disagree with that. I think you could find a fine line if there's a medical underline that they need a puberty blocker. Yes, but that's not the case here. They're using these puberty blockers to transition, and that's exactly what they're doing. They're trying to stop them from a girl becoming a woman or a guy becoming a man with these puberty blockers. Now, so far, I've only heard the side of ACLU. I want to hear the other side. What's going on? We're an hour and 35 minutes into this.
So if I could just make a few points in reaction.
I had one more point,
Okay.
sorry, to add to that. And I don't think, with respect, that what you and the Solicitor General said, we'll just send it back to the district court and they'll make fact findings. It'll be back here in a year and we're going to have this same discussion as I see it. So just to get you thinking about that too. Go ahead. Have at it.
So a few points, Justice Kavanaugh. And the first is I don't see this as the court choosing what is the appropriate response here. What I see the role of the court is assessing whether the choice that Tennessee made is one that they can justify under heightened scrutiny. And so that question is whether or not by taking this decision away from the adolescents, their parents, and their doctors based on claims of harm, that protects children and protects children from adverse side effects. And what I think the record here shows, and again, this is a preliminary injunction record, what it shows is that broad categorical ban does not advance that interest. That doesn't mean that a more tailored response would not advance that interest, in which you may be able to actually come out with a solution to ensure that you are protecting those who may come to regret this treatment, which are much, much smaller than those who benefit and find it medically necessary, something like West Virginia did. And I think the relevant inquiry here is whether what Tennessee did meets their constitutional burden because they use sex-based classifications to pass this law. And then on two quick other points that with respect to the difference between rational basis and heightened scrutiny, yes, of course, it will be weighing the state's asserted interest in both circumstances, but there's a world of difference between rational basis and heightened scrutiny, and we think the Sixth Circuit got it wrong by simply applying rational basis here. And to the question of, is remand, a sufficient?
Well, can I just stop you there? If even under rational basis, if there were no benefit to anyone, then it would probably lack a rational basis. So I guess in the end, you still come down to their risks and benefits both ways. Either way you go here, and I don't know whether rational basis or intermediate scrutiny, however that gets applied, you still have to kind of look, is there a real justification here? I think you look at that either way.
And I think the difference under heightened scrutiny, there's a chance to look at the evidence in a much more substantial way and have the state come forth and show whether they've met their burden. In terms of your question, Justice Kavanaugh, about, well, is it sufficient to just remand it? It will be back up here again. I would say two things in response. I think that there are often examples where there's a threshold question and it goes back down on the application of heightened scrutiny. And I do think an instructive case is Johnson versus California here, in part because it gives us some guidance for what happens on remand in the application of scrutiny. And that, of course, was when the court was considering whether or not to apply strict scrutiny to racial classifications in prison or Turner deference. And when the court reversed and said the wrong standard was applied, strict scrutiny still applies, and sent it back down, it did so with guidance that even under strict scrutiny, the lower courts could take into account the particular context of prison. And I think here, this court could send it back down with instructions to take into account the particular context.
And just one point there, you agree that there's some group of people who receive the treatments who later wish they hadn't and wish to detransition. I know you say it's a smaller group. I understand that. I just want to make sure you agree as a factual matter there is some set of people.
I agree as a factual matter, as there is in all areas of medicine.
And then on the sports question, I want to get your reaction as well, which is it logically and legally possible to apply intermediate scrutiny and say that the Tennessee law and the other laws like it do not satisfy intermediate scrutiny, but laws that limit women's and girls' sports to exclude transgender athletes would be constitutionally permissible? Is that legally and logically possible?
I agree with the Solicitor General that it's legally and logically possible because in the application of heightened scrutiny, it's wholly different state interests that are being asserted.
Thank you.
Justice Barrett?
Mr. Trangelo, I wanted to give you a chance to see if, I'm not sure if you named all of the laws when we were talking about de jure discrimination before. You mentioned bans on cross-dressing and bans on military service. And I had thought of the military service, but I didn't know about the statutes prohibiting cross-dressing. Could you think of others? Are there
I mean, I would say that there are other examples that exist in which sometimes homosexuality and transgender status are sort of lumped together in discriminatory frameworks as language has changed. But I think the most salient to me would be the cross-dressing bans and the explicit bans on military service for transgender individuals.
Okay, and thinking about, when we identify suspect classes, the factors that we've considered, one of the ones that the Sixth Circuit addressed was political power. Do you have a reaction to the Sixth Circuit's discussion of that?
I would just say, Justice Barrett, that I think looking out at the country at the moment, that there is a significant challenge for transgender people to protect themselves in the political process, where you do have laws excluding transgender people from places where they need to go in all aspects of life, and there is a difficulty in that type of majoritarian protection. I think that's precisely
They need to go to the bathroom? What do you mean?
what the political powerlessness prong of the test accounts for.
Thank you.
Justice Jackson?
So I guess
She didn't even really answer when she asked her for some more other cases. She said the military, and she said, well, I think there's others, but more with gay men and the cross. But she didn't give nothing.
I guess I'm suddenly quite worried about the role of the court questions and the constitutional allocation of authority concerns, because I understood that it was bedrock in the equal protection framework that there was a constitutional issue in any situation in which the legislature is drawing lines on the basis of a suspect classification, that it's a constitutional question that is being raised when that is happening as a threshold matter. And then you may get into why is it happening, what is the justification, and you've said here at the podium today that the different levels of scrutiny account for how strong the government's evidence has to be for doing that, and the court really holds them to it in a heightened scrutiny scenario. But the kind of initial issue is that a law is drawing lines on the basis of some suspect classification. Does that accord with your understanding of what we normally do? And that's a question for the court, because it's a constitutional question. Is the statute doing this, right?
Yes, I completely agree with that, Justice Jackson. That's precisely why we think heightened scrutiny applies here, because this is a statute that on its face draws.
All right, and to answer the question, is this statute doing this, I understood that we had a sort of two-step framework for looking at it, that we don't just kind of launch into an assessment of the evidence or why the state is saying that they're doing this, or the scientific basis for it, that we're looking at something else when we're trying to determine is a classification being made, right?
Yes.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel, because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says, the argument is that if the Equal Protection Clause does not outlaw miscegenation statutes because of their reliance on racial classifications, the question of constitutionality would thus become whether there was any rational basis for a state to treat interracial marriages differently from other marriages. On this question, the state argues the scientific evidence is substantially in doubt, and consequently, the court should defer to the wisdom of the state legislature in adopting its policy of discouraging interracial marriages. And so for me, this kind of idea that the way we look at it is not first, are you drawing these classifications, and then state, give us your evidence so we can make sure that there's a proper fit. If instead we're just sort of doing what the state is encouraging here in Loving, where you just sort of say, well, there are lots of good reasons for this policy, and who are we as the court to say otherwise? I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
I share your concerns, Justice Jackson.
We
I
know
think
how
one of the
she's
things
gonna
that's
vote.
happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
Thank you.
Thank you, counsel.
Well. Well, they said kick it back down to the states because they didn't have enough evidence about interrelational marriages, relationships. So she's afraid. She's nervous that this is what they're going to do with this. I mean, these are adults that they were talking about, interrelational relationships. Yeah, it was frowned upon. Now nobody gives a shit. But this is different. This can't be a classification of a race. This is minors. You pass laws, they can't drink until they're 21. They're not considered an adult till they're 18. And I don't see how they're making this parallel jump. Or either obviously she's trying to make a point, but I think the point is mute.
Mr. Rice?
Mr. Chief Justice, and may it please the court. Tennessee lawmakers enact.
All right. I think we're getting started on this other guy. We're going to wrap this one up. This is part 3. I don't know. That right there. Trying to equate that. And again, I'm not an attorney. I'm just watching this with you guys. Let me know what y'all think in the chat. Just man, that's unbelievable. Well, they go kick it back down because then the states say, well, let the states decide if they want to have interrelational marriages. And how they kicked it. Maybe she's making that reference as if they just kick it down and let Tennessee decide how they want to handle the children. I mean, is that she's trying to make? I think that's a stretch comparing that ruling to this. Because it's completely 2 different things. And to say that it's got to be classified as like a race, this is not a race. It's children. They're minors who can't make decisions on their own. That's the whole crutch and caboodle of the whole thing. Please like and subscribe and share and have a good one. End of part 3.